Hello, get ready. 5 seconds. On perusal of the pleadings of the parties, it is clear that the defendant had admitted the receipt of rupees 10 lakh as earnest money from the plaintiff on 10/8/2006, and it is also admitted that the defendant has agreed to sell the sued property to the plaintiff while agreement dated 10/8/2006 stopped. The defendant, while appearing as DW7 in his affidavit, exhibit DW7/A, tendered in evidence by him, has admitted the receipt of earnest money from the plaintiff and the execution of the agreement of sale of the sued property in favor of the plaintiff for consideration of rupees 25 lakhs stop. Thus, in view of this, the execution of agreement exhibit PW1/B not in dispute stand established on record, and it is also established that the defendant has received the earnest money of rupees 10 lakh from the plaintiff stop. On perusal of exhibit PW1, it is clear that while agreement the defendant had agreed to sell the suit property comprising a house in favor of the plaintiff for consideration of rupees 25 lakh, out of which receipt of rupees 10 lakh has been acknowledged by the defendant, and it was also agreed between the parties that the sale deed will be executed on 10/2/2007, which recital in the agreement appears to be incorrect from the face of it, as agreement has been executed on 10/8/2006. It is also mentioned in the agreement that the balance consideration amount will be paid at the time of registration of the sale deed, and in case the vendor fails to execute the sale deed, then he would be liable to make the payment of double amount of the earnest money, and purchaser would be having right to enforce this agreement by filing a suit in the court, and in case the purchaser fails to perform her part of the agreement, then the earnest money paid by her to the vendor shall stand forfeited, and agreement entered into between the parties shall stand cancelled/rescinded. Stop. Para. The plea of the plaintiff is that the defendant has failed to perform his part of contract and now has totally refused to execute the sale deed qua the suit property in her favor, and as such she is entitled to recover the earnest money and paid by her to the defendant, whereas the plea of the defendant is that it is due to the act and conduct of the plaintiff that sale deed in pursuance of the agreement could not be executed within the stipulated period, as such earnest money paid to the plaintiff stand forfeited. Accordingly, the plaintiff is not entitled to recover the same from him. Stop. Para. The plaintiff, while appearing as PW1 in her affidavit, exhibit PW1 has asserted that the land comprising Khasra number 66 in joint land of the defendant and the other co-sharers. Stop. As per copy of Jamabandi, the house which was agreed to be sold to her by the defendant is stipulated over joint land, and therefore sale deed qua the said house could not be executed without the consent of the other co-sharers. As such, she asked the defendant to obtain no objection certificate from the other co-sharers so that the sale deed could be executed, but the defendant kept on lingering the matter on one pretext or the other, and in such manner the sale deed regarding the suit property could not be executed due to act and conduct of the defendant. And when she asked the defendant to return the earnest money, then the defendant refused to do so. Stop. She was cross-examined on behalf of the defendant, but nothing contrary could be elicited in her cross-examination. Stop. She is specific that the copy of Jamabandi was not available at the time of agreement, though she has stated that she has signed the agreement exhibit PW1 after fully understanding its contents. Stop. Please like and subscribe my channel for latest updates.